Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Lynn Thompson, a Mississippi construction lien law expert. Today's webinar topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Lynn Thompson.
Good afternoon to all of you. We're going to pick up this super fun webinar here where we left off with our prior one, which focused on the steps to record a proper lien on a private construction project. All of Mississippi's lien rights are established by a statute, so you've got to make sure that you comply with all those particulars of the statutes, because they're going to be very strictly construed by the courts. I've been practicing construction law for over 30 years, and you never face a day where a client presents you with an issue you haven't met before. So even with lien laws, knowing what the statutes are, it's very important to pay attention to all the facts of your project and what's going on to make sure that you can remain in compliance with the law. So from the date you file your lien, there are lots of things or several things that you've got to calendar. You calendar the date that the lien is recorded, and you mark your calendar for the next steps that you have to take after that. So once you have perfected your claim of lien, that means you have timely recorded in the Chancery Clerk's land records in the appropriate county your claim of lien. Your lien contains all the required information, and you have timely sent a copy of the lien to the owner and or the contractor by certified mail or statutory overnight delivery. Only at that point is your claim of lien perfected. After that, you've got to mark your calendar for filing either a payment action, we're filing either the payment action or a lien action. Now, you mark your calendar. Both of these actions have the same number of days in which you will have to file, and I'll get to that in just a minute. But a payment action is the action that you file against the party that owes you the money. A lien action is where you have to file against the owner of the property. You can include as a defendant the party that owes you the money, but that is not necessary under a lien action. Now, what is the difference? A payment action is where you sue the person that owes you the money. That'd be the person that you contracted with. But sometimes that person or that entity is they can't be sued. And what are those times? A lien action is when you have to file against the property itself and the owner, because the party that owes you the money has been adjudicated a bankrupt, or the party that owes you the money was an individual that has died, or payment is not yet due to you under the terms of the contract until after the payment is received by the party you contracted with. In essence, if your contract, say you're a subcontractor dealing with a prime contractor, and you have a pay if paid or pay when paid clause in there, if that clause exists and the owner has not yet paid the prime contractor, then you should consider filing a lien action to attach to the property itself. Now, note here that it says a list pendants notice must be filed. What is that? Well, a list pendants notice is a document filed in the land record, same place you would file a lien. It's a notice that gets filed with the clerk that says that this piece of property is subject to litigation. Now, the importance of this is that if you fail to file the lis pendens at the same time that you file the payment or the lien action, then your lien is invalid. You will no longer have a lien to pursue. There actually is a Mississippi court case that held that a lis pendens notice that was filed some several weeks after the payment action was initiated invalidated the lien. So whoever you're using to file your actions, make sure that they are aware of this lis pendens requirement. Okay, now that you know what you need to file, where do you file it, and when do you have to file it? Okay. In Mississippi, we have county courts and circuit courts, and those you would file there depending on the amount of your claim. If your claim is above the jurisdictional amount of the county court, you could file in circuit court. You can also file in chancery court. There's no jury in a chancery court. And you may have to file for arbitration if your contract requires arbitration. And I'll get back to that in just a little bit. Okay, when do you have to file the payment action? You have 180 days after you file the your claim of lien. You have 180 days to timely file your payment action. And the if you have amended your lien, which you can do, you know, sometimes you're going through a project and at first the amount that you're entitled to lien is, say, $100,000. And then another pay period goes by and you still hadn't been paid and your claim of lien goes up to $150,000. You can file for an amended claim, but just remember that though you amend the lien amount, it doesn't change the original date of filing for purposes of filing a payment or a lien action. You need to look to the original date that your claim of lien was filed. Now, if you receive a notice of contest of lien, it's 90 days. If an owner gives notice of a contest of lien, and the time in which you have to file an action is going to be cut down to 90 days from the date of your original lien filing. All right. And this is talking about the notice of the contest of lien. An owner or an owner's agent or attorney, or the contractor or the contractor's agent or attorney may elect to shorten the time prescribed in which to commence a payment action to enforce any claim of lien by recording in the Chancery Clerk's office a notice of contest of lien, along with proof of delivery to the lien claimant. Now, you need to look for this. Lien claimants have to send a registered or statutory overnight notice of their claim of lien to the owner and the contractor within 2 days of filing their notice of lien. So you need to be looking in the mail or from FedEx within 7 days thereafter for receipt of a notice of contest of lien. This contest of lien has to be sent by the owner or the contractor who's contesting the lien within 7 days of receipt of your notice. And this is what a notice of contest of lien would look like. Actually, this refers to the 60 days. Okay, now, what do you have to file? A lien action or a payment action is really no different than any other lawsuit. You're going to have to prepare a summons that the clerk will issue, and you have to file the complaint. And you have to allege in the complaint, you know, the bases of the contract terms, of the payment terms, or whatever that give rise to your claim of lien. And you're going to have to take that summons and the file complaint and serve it on the party's defendant. It could be the owner and the contractor. It could be just the contractor. But whoever you've named as a defendant, you have to serve them as you would in any other lawsuit in Mississippi. Now, what happens if you do not commence your payment action on time? You lose your lien right. You don't lose your right to maintain a breach of contract action, but failure of a lien claimant to commence the payment action within 180 days from the date of filing the lien renders the claim of lien unenforceable. And that's just what the statute provides. If you have a lien that there was a notice of contest of lien that was filed, this statute, Mississippi Code 857-423, provides that your lien is extinguished by law upon the earlier of 90 days after the filing of the notice of the contest of lien. So if you receive a contest of lien, you have 90 days. Otherwise, it's 180 days. And no release or voiding of the liens is required. In other words, your lien right, or your right to claim a lien is automatically voided. Now, who do you have to sue to enforce your lien? You can sue the person with whom you have a contractual relationship. That may be the prime contractor. It may be a first-tier subcontractor if you're a material supplyman. But you can sue the party with whom you have made your contract. You can add the owner. You are not required to. But this lets you know who all may be a party to the lawsuit. You may sue, for instance, just the contractor, but these defendants can add other parties who may also have an interest in the claim or who may be affected by your lien. So there, you can also look sometimes for parties to seek to intervene in the action that you have initiated. When you file an action against the owner to enforce the lien, remember that's a lien action, it's different than a payment action. The owner can put into issue any facts which affect the value, which affect your right to recover on your lien. For instance, if an owner has paid a paid application of a prime contractor, and that payment application included a lien waiver that you signed, even if you ended up not getting paid, the owner can rely on that, and the owner could put that fact at issue in the lien action. So the point of this is to let you know that you will have to prove up your lien. You will have to provide all the facts, whether you've sued the contractor or the owner, to support the fact that your claim of lien is justified in whole or in part. Now, the courts in Mississippi are entitled in their discretion to award the reasonable costs, interest, and attorney's fees if you prevail in your action against the owner to enforce a lien against the property. You're not entitled to attorney's fees, but the courts are free to award them in their discretion. So if you're going to file a complaint, you need to be sure to include in your demand that you seek attorney's fees, reasonable costs, and interest. Okay, suppose your lien is actually satisfied. A lot of times in my experience, the filing of the lien shakes loose the money. The liens are very effective as a means of debt collection. So if you're lucky enough that the lien itself secures payment to you, then you've got to make sure that you remove the lien. You must file something to file a notice of cancellation of the lien. Now, if you go to court and you have to file the payment action, you secure a judgment, and the lien amount is determined and eventually paid, then also you will at that point be required to file a notice of lien cancellation. And you file it in the same place where you filed your lien. Now, there is a penalty in Mississippi if you've been paid and need to file the notice of cancellation. If you've been awarded a judgment that's been paid, you must also then file the notice of cancellation of the lien. And they've got to do that. You have to do that within 15 days after receiving a demand in writing to file the cancellation. So let's say the prime contractor has paid you the money that you were owed and writes you a letter saying you must now cancel this lien. If you don't do that within 15 days, then you are subject to a penalty of not less than $500 per day. And you'll be required to pay the reasonable attorney's fees and costs for any action to have to enforce the cancellation of lien. Now, I mentioned arbitration. In Mississippi, filing a demand for arbitration does not toll the statute of limitations. So what you'll have to do is when you file your payment action or your lien action, you need to include in there that you are preserving your right to require arbitration if that is in your contract. Typically, that's how we file things. We, asserting there's a right to arbitrate, which is not being waived by the filing of the payment action. And thereafter, the parties typically enter into a stay of the payment action filed in court until such time as the arbitration proceeding is concluded. But this statute in Mississippi just lets you know that your right to file a claim is recognized by law. You can file the payment action or the lien action to secure payment of the lien, but the dispute, you're having entered into an arbitration agreement with your contracting party, that can still be enforced. So instead of going into court to prove up your claim, you'll stay that action, proceed to arbitration, and then, depending on the outcome of the arbitration, lift the stay and go back into court to do whatever is required by the arbitrator's ruling. So you don't lose your right to arbitrate when you have the right to seek satisfaction of a lien. And the party with whom you've contracted does not lose their right to insist upon that arbitration. Okay, construction liens, there's no priority. And this is why when a payment action is instituted, other parties may seek to intervene to have everyone's right to money determined, right to satisfaction of their lien determined in one proceeding. So the liens don't have a priority. The first to file the payment action doesn't really get an advantage over others who are joined later, because the proceeds, as you can see here from this statute, the proceeds and money shall be distributed pro rata among the claimants, or as otherwise ordered by the court. So if by the time you file your lawsuit to enforce your payment action to enforce the lien, if the money collected from the owner isn't enough to pay all of the lien claimants, then it will be distributed pro rata. Which is also another good reason why if you hear that a lawsuit has been filed by a party to enforce their lien, you need to seek to join that lawsuit to be part of it. Okay, this is something a lot of folks forget, particularly clients from out of state who are performing construction work in Mississippi. In order to pursue a lawsuit in Mississippi, you've got to be actively registered with the Mississippi Secretary of State. Not all projects extend for more than a year, but there are times when I've had out-of-state clients allow their Secretary of State registration to lapse. You need to keep that up to date in order to be a plaintiff in Mississippi. Make sure that your certificate of responsibility does not lapse in the interim. Of course, in Mississippi, you can bid or submit bids or enter into contracts on private construction projects that exceed $50,000 if you do not have a current and correct certificate of responsibility. But in order to maintain your lawsuit, just make certain that you have kept that up to date. And then again, you should sue in the name of the business entity that entered into the contract. That's all part of minding your corporate particulars and avoid getting a motion to dismiss or some other effort to get rid of your lawsuit for not following these simple steps. So that is Mississippi lien law, the very basics of it. And again, your right to recover will depend on the facts, it will depend on your performance, it will depend on the terms of your contract. But if you follow the law and follow your contract, you should be in good shape.
Lynn, are you able to go to the next slide for us?
Sure.
All right, perfect. Thank you so much, Lynn. You really are wonderful. I do appreciate it. There were a couple of questions that have come up. I think this is based on one that you just kind of touched about a little bit ago. It says, if you have only received partial payment after filing the lien, are you required to record a partial satisfaction of lien, or is that $500 penalty only for the full and final payment satisfaction of lien?
Okay, if you have filed a lien, let's say you filed a lien for $100,000, you receive a partial payment, then you should amend your lien to record the amount that remains owed. So that's not really a cancellation of lien because it hasn't been fully satisfied. It's just been reduced. So I would just file a reduced, an amended lien for, say you got $50,000, I'd amend the lien for $50,000. But that, okay, unless fully satisfied, I don't think you're in the cancellation of lien situation.
Okay, perfect. Thank you very much for that clarification. It says that I saw that a lien must be delivered to the owner or prime contractor within 2 days of filing. Is this both for commercial and residential liens, and should it be FedEx to ensure delivered within 2 days?
It must be sent within 2 business days. It can be either by certified mail or return mail, or a statutory overnight mail, which is, like FedEx, but it needs to be overnight mail. And I would apply it to both residential and construction projects. And I found the statute on the residential construction.
Okay.
Says that if you're not in privity with the owner, then the claimant must provide the owner a pre-lien written notice at least 10 days before filing the claim of lien. So I think they have to receive the notice at least 10 days before filing the claim of lien.
I think the question was, is that the 10 days based on when that notice to owner was signed or when it was mailed?
They have to, I would say it's 10 days before the owner receives it.
Okay.
I'm sorry, we pay 10 days of the receipt of it. The purpose of that is that the owner in a residential setting has the opportunity to prevent a lien from being filed. So if you sign a lien and then you wait 15 days to send the notice, that doesn't really help the owner any. What you want to do is get it in the hands of the owner so they can have at least 10 days to resolve it before you file the lien.
Okay. All right, wonderful. Well, thank you so much for being able to confirm that for us. That seems to be all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Lynn, can you go to the next slide for us, please?
Glad to.
Okay, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember each state has its individual documents and deadlines associated with their lien laws. So please, please, please make sure you're checking that out to make sure that you're properly, protected and your lien rights are secured for whatever state you're working on. Please don't assume that just because you're working in one state that those same laws and deadlines apply to your neighboring state, because most likely it will not. All right, and then the next slide, if you don't mind, please. All right, so if you don't mind, give us a quick moment of your time. It only takes about a minute. We'd love to hear some feedback from you. It always helps us better ourselves and the content that we're putting out there to deliver to you guys of what you're looking for. So we really do appreciate it. And then the next slide, if you don't mind. All right, that is all we have for you guys today. Thank you so much to everyone who was able to attend. We hope to see you at our next webinar. Lynn, you really are fantastic, so thank you so much. I hope everyone has a beautiful and sunny day. Thanks, everyone.